All right. Welcome everyone to Michigan Lakes and Streams Association's spring webinar series. This is sponsored by the Glen Lake Association, so we thank them for helping us put these webinars on. We're so happy to be able to provide this experience for you. We are into May now, and so, you know, this is, I think this is our first one in May, and we have 2 more after this one as well. So this has been very successful, and we thank you all for joining us. You are not on video, and you are also automatically muted. So you can relax. We cannot see you. We cannot hear you. We do have the Q&A open, and the Q&A box is a place where you can write in questions as we go if you have questions for our speaker today. We will also try at the end to do some live questions. If you raise your hand, we might be able to do that at the end. But during the presentation, we'll stick with the Q&A. And also, this is being recorded. There is a recording happening right now, and the session will be available on our YouTube channel. And there's a link from our website, mymlsa.org, mymlsa.org, so that you can view this again. You can share it with your friends. You can go look at any of the sessions that we've had during this spring webinar series. So we encourage you to do that. So today we have with us our MLSA board member and attorney, Mark Teicher. You can see here some background about Mark. He's a busy guy. I mean, he's got lots of accomplishments here. He specializes in negligence. He practices statewide. He has been practicing for 38 years. He's also just told me about his own personal experience on a lake. Not only is he the president of his local lake association, but he also, his family has had his lake cottage for 90 years, 5 generations. So lots of experience there, a wealth of knowledge, and we really appreciate him being here with us today. So Mark, I am going to turn it over to you. So I will stop sharing this at the moment, and I will.
Hi, everyone. Thank you very much for being here. Thank you, Melissa. Thank you for all our dues-paying MLSA members and for anyone else who's interested in MLSA things. So today what I'm talking about, of course, is a serious subject. It's been on many of our minds lately. It's sometimes felt to be very pervasive. People sometimes don't think it's going to affect them, but it does. No matter what you do, it can affect you. It can be just feel like it sucks the life out of you, and it can be a terrible feeling. You all know what I'm talking about. I'm talking about tort liability. Yes, I know that's what you were thinking about, tort liability. So certainly the virus is going on, and that's a terrible, very serious subject. So I wanted to bring a little humor in today. So here's a little bit of humor on the screen. It might be very little, but I'm going to try to keep it somewhat light, although your questions will, of course, be treated seriously. Okay, so we'll give you a minute to look at this. Next, okay, so there's, thank you. Melissa is handling, and thank you, Melissa, for handling all the postings. So now we can move on to the first serious slide. And oh, before we go to the first serious slide, we have, go back a minute, Melissa. So we have the one that says, torts are us. And we're talking today about torts, about negligence. And torts are injury cases, like sometimes you see injury attorneys who advertise on TV. I do not happen to advertise on TV. But it seems like some people treat torts maybe like the lotto, like they expect to get the world. They typically do not get the world. And there are lots of rules that we're going to learn about negligence and about insurance law. Now we can move forward. So negligence, okay, so what we're talking about is negligence and insurance law. First, we're going to talk about some definitions. The first definition I have up is negligence itself. Negligence is the failure to use ordinary care. Ordinary care means the care that a reasonably careful person would use. Therefore, negligence means the failure to do something that a reasonably careful person would do, or the doing of something that a reasonably careful person would not do under the circumstances. So this is the standard in tort law to see if you're negligent or not, or if you're going to be held liable. So if you were being sued, this is the general negligence standard. There are many exceptions, but this is the general negligence standard. One of the exceptions, standard of conduct required for the safety of a child. When we talk about children, and children means anyone under the age of majority, so that means anyone before their 18th birthday in Michigan, the law recognizes that children act upon childish instincts and impulses. If the adult knew or should have known, so if you knew or should have known that a child or children were likely to be in the vicinity, then you as the adult are required to exercise greater vigilance, and you are held to a higher standard than just a reasonably careful person. The reason that I brought that up is I've thought about all the times where we have friends bring their children out, and where children have gotten hurt, never seriously, but have gotten injured, and the standard that I or you are held to is much higher for the child. Whether or not the parents are there, we as the owner of the cottage or of the boat or of the dock are held to this higher standard to ensure the safety of children. Okay, we can move to the next slide. There are many statutes that apply to us as riparians. For example, there are statutes and ordinances and regulations that govern our use of boats, our use of tubes, our use of water skis, our use of watercraft, our use of personal watercraft. So if it's a statute refers to a state law. So this is in the case of an injury and you or I have violated some statute. So if you or I violate a statute before or at the time of the injury or damage, so injury would be to a person, damage is to something else like hitting another boat or hitting someone's dock, then it's inferred that the adult, that you or I, was negligent. So what does this mean? This means that if someone gets hurt on your boat, and there are statutes that you have been found to violate in the investigation, such as too many people on the boat, such as not enough life jackets, then there's a legal inference that you are negligent. There are exceptions, but basically you are negligent. We go down to the next, negligence when in violation of an ordinance. So an ordinance would be the township, the municipality, the village, the county. Those are ordinances. If an adult, if you or I, are in violation of an ordinance before or at the time of the injury or the damage, then the violation is simply evidence of negligence. And the third type of negligence in this category is violation of a rule or regulation. For us as riparians, DNR, DEQ, and EGLE have a variety of rules and regulations. They're not statutes, but they put out the rules and regulations. And if we violate one of those, although it looks like my typing was off, if an adult is in violation of a rule or regulation before at the time of the injury or damage, then the violation again is evidence of negligence, not the inference of negligence. What does this mean to you or me? In very practical terms, this means if someone is a state officer, such as a state patrolman, although I don't think state patrol usually has people on the lakes except for DEQ officers, DNR officers, conservation officers. If a conservation officer gives you a ticket, that ticket is a violation of a statute because they're applying state law. So if they give you a ticket or charge you and you plead guilty or are found guilty or plead responsible, then there's the inference that you're negligent, that you're at fault. Big difference. If a township police officer or a sheriff from your county comes and is going to give you a ticket, it's a big difference if that officer gives you a state ticket that you are, it'd be a township or a county ticket, but if it said that you violated state law, there would be an inference of negligence if you're found responsible or guilty. If it was their own ordinance, then it's just evidence of negligence. So if you're ever stopped, not that you will be, by a township police officer, maybe because they say you're driving your boat too fast, then you might want to beg for mercy, at least in terms of, can it be an ordinance violation instead of a statute violation? Because then, if, for example, someone was hurt or if there was damage, then there would not be an inference of negligence, there would simply be evidence of negligence. So let's stop a moment and let me open it up. Does anyone have any questions thus far about what I just talked about?
Yes, actually, we did have a couple of questions. We had one here. It's Jeffrey says, what if, let's see, what about if the injured person is partially at fault and I guess the property owner or you are partially at fault?
There is a proportion given to who's how much at fault. So that's a good question. That comes in kind of differently right now. I just wanted to deal with these definitions, but good question. So if in fact this went, for example, to a jury trial, a jury is instructed that in this boating accident, who's how much at fault, and the jury can, for example, say, okay, someone's injury is worth $100,000, but the person who was hurt was 20% at fault, then that 100,000 would be reduced by 20% to the tune of getting $80,000 instead of $100,000.
Okay, and then there was sort of a related question. If you personally represent individuals who are given tickets, that's something that you do?
Yes.
Okay. And then another question here, what is the difference between inference and evidence?
So the difference is that an inference means that, and I think of things kind of as a worst case scenario, that someone's either charged with a crime or someone is sued and they're going to trial, a jury trial, let's say. So a judge, if there is an inference, that means the judge actually tells the jury that this adult, this person, Mark Teicher, in driving his boat, that you can infer that he was negligent. So what that really means is that I would have a large burden of proof to overturn that inference that, no, jury, I wasn't at fault, even though the judges instructed you that you can infer I wasn't at fault because I violated a statute. The difference is that if it was an ordinance violation and it's simply evidence, then the judge instructs, here's a whole pile of evidence. Here's 10 different things that are pieces of evidence as to who was at fault, like the prior questioner, who was how much at fault, and was Teicher at fault. That if there's 10 pieces and it's just evidence, then that evidence of the violation of the ordinance is just one piece, as opposed to the judge, an inference would be that it's automatically majority, so to speak.
All right, and we had a hand raised by Lon Nordine, one of our other MLSA board members. He would like to ask a question, and you're unmuted, Lon, so you can ask your question. Okay. We also had another.
Wait a minute, it's always hard to keep Lon Nordine quiet. I don't understand, I don't hear him.
It must be having a technical difficulty. We did have another hand raised though, so I'm going to unmute Jeffrey Schaefer, and you can ask your question, Jeffrey.
I'm not hearing anything.
I'm not either. And Jeffrey and Lon, I apologize if this is a technical difficulty we're having. I've not had this happen before. So, you know, if you are able to type in your questions, if that will work better for us, I apologize for that. That is inconvenient. But let's see, we do have a couple of questions in the box. Oh, I see. Okay, so Jeffrey did try to write some things in the box. So he's looking for information about meeting with you. So I'll type in some information for him about how he can get a hold of you, and then we can
Okay.
we can move on. All right.
So we can go to the next slide.
Okay.
So this is more about negligence. What about if someone's negligent when they're intoxicated? And intoxication includes not only alcohol, but drugs, and not only drugs, but also marijuana. Certainly there are issues with testing the level of intoxication or impairment with certain drugs like marijuana, but the law applies the same. And the law, as I see it, says, one who voluntarily impairs his or her abilities by drinking or drugs is held to the same standard of care as a person whose abilities have not been impaired by drinking or drugs. In other words, as far as negligence, it's not a defense. It has nothing to do with negligence. It doesn't, I mean, it might be evidence of negligence, but it is not in any way a stop or a dam to being negligent. Sometimes people hear the term gross negligence. Gross negligence means conduct or a failure to act that is so reckless that it demonstrates a substantial lack of concern of whether an injury or damage will result. I threw that in insurance terms. Negligence or gross negligence usually doesn't matter. Typically, if you are negligent and you have the correct homeowner's insurance or boat owner's insurance, the insurance company will defend, in other words, pay for your lawyer and pay any settlement up to your insurance limits, whether you are simply negligent or grossly negligent. Oftentimes, gross negligence comes in on a criminal side. If someone's hurt, it might depend on what you're charged with as to whether you were simply negligent or grossly negligent. Okay, next. Other terms that you often see in insurance policies and in the law in general, you hear about wanton misconduct. Wanton misconduct means conduct or a failure to act that shows such indifference to whether harm or damage will result as to be equal to a willingness that harm will result. That's important because that's a whole new level of showing not caring about someone else getting hurt, and that will kind of come in a little bit later as we continue talking. Another term that one hears a lot about is proximate cause, and this relates to, I think, the first question. Proximate cause means the negligent conduct must have been a cause of the injury or damage, and that the injury or damage must have been of a type that is a natural and probable result of the negligent conduct. So it's the connection between the negligence and something bad happening. There can be multiple proximate causes. In our example, I'm driving my boat. The jury finds me 80% at fault, so I'm an 80% proximate cause. However, maybe the other boat I hit, they found to be 20% at fault. They were a 20% proximate cause. Next. Now we're going to three terms: invitee, licensee, and trespasser. These are extremely important because under the law of negligence, to be liable, to be responsible, to be held responsible for someone for monetary damages because they were on your property and slipped and fell, got injured on your boat or whatever, or on your dock, that it depends what kind and how much duty, legal duty, you actually owe to that person. And you owe the amount of duty and the quality of the duty based on if they are an invitee, a licensee, or trespasser. And you owe some duties to all three categories. First, invitee. An invitee is a person who is invited to enter or remain present on your land, your boat, or your dock for a commercial purpose. So if you have somebody out, you're surveying your property, and the surveyor slips and falls on your dock while they're surveying things, that would be an invitee. If you run a business out of your house, that person may be an invitee. A licensee is a person invited to enter or remain on your land, your boat, or your dock for other than a business purpose, often called a social guest. You invite your friends over from a couple of cottages down. You invite some city folk in to spend the weekend with you or just the day with you. Those are social guests. Those are licensees. Third category is a trespasser. A trespasser is someone who comes upon your land, your boat, or your dock without your express or implied permission for his or own purposes. Maybe to steal something, maybe to jump off your dock, maybe to play with one of your water toys while you're not there, whatever. So invitee, licensee, trespasser. Next slide. So the next slide is delineating, showing what duty you have to people in each category. So the duty to the invitee, you have a duty to use ordinary care, and we defined ordinary care before, to protect an invitee from risk of harm from a condition on your land, on your boat, or on your dock, if the risk is unreasonable, or if you know or should have known of the condition and should have realized that it involved an unreasonable risk of harm. Duty, can you raise it up a little bit? Duty for a licensee. Melissa, can you raise the slide?
Yeah, I actually can't raise it.
So,
sorry. Do you want me to read it though? I can see it.
Okay. Because is the third duty right below, or is it?
It's on another slide. I couldn't fit them all.
Slide? Okay.
Yeah,
So,
that's why.
Duty for licensee. You are liable for physical harm to a licensee. This would be a social guest or your friend. If you knew or should have known or realized that the condition that injured your licensee, your friend, involved an unreasonable risk of harm, and that you failed to warn them of the danger and that the licensee did not know of the danger. And next, let's go to the third one, then we'll talk about it a little bit. Duty to a trespasser. You have a duty to a trespasser to not act with willful or wanton misconduct that may injure the trespasser, or that you were aware or should have been aware of the trespasser's presence on your land, on your boat, or your dock, but failed to use ordinary care to prevent injury to that trespasser, or that you were aware of the trespasser's constant intrusions and that the trespasser's activity involved a risk of death or serious harm. Then you have a duty to exercise reasonable care to keep your land, your boat, your docks reasonably safe so not to endanger the trespasser. So for the trespasser, for example, let's say that this is your weekend cottage, that you go back to the city and back to the real world, whatever that real world is right now, during the week, that you can tell that someone is on your dock during the week. You don't know who it is. You don't have enough cameras or security up at your cottage. Nobody sees anybody. And let's say that you also know that one of the wooden planks on your dock has a crack in it. And if someone steps right on that crack, that they're going to fall through and they're going to get hurt. So that's the condition where you know someone's trespassing. You don't know who it is. You know that there is some risk of death or serious harm, and you don't replace the plank, so you don't take reasonable care. So if that trespasser then falls through the plank and gets injured, you may well be liable for that trespasser's injuries, or death, or damages. Okay, so let's stop here a moment and see if there are any questions about invitee, licensee, and trespasser. And if not,
there was just one question. I think it might still be related, and then there's another question coming in. Charlie asks if he builds a seawall to protect his home from high water and it causes higher water to my neighbor, am I liable? Is that a liability issue?
Wow, Charlie, that's a good question. I don't know the answer to that. I am not sure how large of a body of water you're on, that if you put a seawall, that it would raise everybody's water equally.
Unless he's talking about scouring, or, you know, like there can be some effect on someone else's.
Yeah, at MLSA, we have run articles and issues of if you put up a seawall and the damages that can happen on waves that can then damage another person's property. That one I'd have to think about a bit. I don't know the answer to that off the cuff, but good question, Charlie. Maybe I'll think about it while I'm talking and get back to you at the end, Chuck.
All right, so there's a question here. Someone has 20 acres and they have hiking and cross-country skiing, biking. They're on good terms with their neighbors. Their neighbors have started using their trails. They're okay with that. What are the liabilities associated with like a trip or a fall or a fracture of a hip? And then how about if a trespasser does the same? They did say that their parcel is posted for no trespassing.
Okay. Well, let's go back up to invite to the licensee. Next, the prior slide.
Okay. See if it'll let me. Yeah, it wants to go that way. Okay.
So in general, where it talks about these would be licensees, people who you have allowed onto your property. They're not there for a business purpose. They're not paying you. And this is my summary of the law. Again, there's lots of exceptions. There's always exceptions to everything in the law, but it basically, you're liable for physical harm to those people who use your bike paths if you knew or should have known or should have realized that there was some condition, meaning some dangerous condition, that injured that person, that it involved an unreasonable risk of harm. So if in fact your trails are all safe and there's really no harm, unreasonable risk of harm, that it's all pretty flat, maybe rolling hills, there's no tree branches in the way, there's no holes, there's no all of a sudden rocks that somebody might hit. It seems that there is not unreasonable harm. However, and the original title of this lecture, to get people to watch, what was Sue the Bastards. And I say that because a lot of times, whether it's neighbors or sometimes family, that when somebody gets hurt, all of a sudden I hear Sue the Bastards, and they should have taken more care and they should have looked out for me more. So even though you're on good terms with your neighbors, you can do as much, if you want to continue to be good neighbors, you could do so much as to have them sign a waiver of liability form saying you can use my property, but you have to waive if you got hurt. I would probably suggest a good start would be if people either hike and or bicycle on your land, that you hike or bicycle it and make sure that it seems reasonably safe and no unreasonable risks. Because if in fact someone gets hurt, there is typically some attorney who can find some expert to say that that yes, the property is generally safe, but at one there's a boardwalk that they were biking on, and they bicycled right off the boardwalk, and although you've had the boardwalk there for 50 years, someone bicycles and goes right off it and gets hurt, they might say, well, you should have had a sign up, or have, a lot of times it comes down to what experts will say or testify to.
A follow-up on that was, for that same situation, was natural conditions like stumps and depressions in the land, normal land contours.
Well, it does make a difference if they're natural, but again, even if it's natural, if it's an unreasonable risk of harm. So if in fact you've set up a trail and it goes right to the stump and then takes a 90-degree turn, and no one's ever bicycled to the stump, and then someone does, even though the stump might be natural, or your trail is just, you know, stepped on grass, and it's not like you put up a boardwalk, you could still be held liable.
Okay, so even if it was not a trail, that was another question. So we're talking about a natural area, no trails made.
Well, I think that if you have signs posted that say no trespassing, that's part of an appropriate warning that might relieve you of some liability.
Okay, so all right, there were a few questions about that, about the sign that shields does posting the sign shield liability, and it looks like we're looking for some clarification about some of these definitions. So we'll start with that one on a trespasser. As far as posting a sign that does, how much does that shield your liability?
It shields you to a high degree, but we're going to get to another slide that what it doesn't shield you from is liability when it comes to children or minors. And there's a slide we're going to get to about that. So maybe we should go to that slide right now.
Well, if you don't mind, there's quite a few questions about like associations, like homeowners associations, cottage associations, and you know how this applies to them. So there's quite a few of them that are all related from different people. One of them specifically says, are the members of your cottage association licensees or invitees as at the association facilities? So if your association owns facilities or property.
Well, I was addressing this as a homeowner, but these are the definitions to apply to your home or cottage. But in general, they apply to if the association owns a property and like has an association picnic. I think they would be licensees, because even though someone's there for the association, they're not there for a business purpose. Although it might get a little overlapping if there's a business meeting. And we've certainly had events where there's a business meeting, so the board members are there, but the family members all come. So some might be invitees, some might be licensees, so there might be different duties owed, different levels of duties owed to different persons.
Okay, and then also related to that, as far as a homeowners association, would they be responsible for a trespasser who is harmed on a homeowners association owned beach or dock? And then it follows up, the follow-up for that question is that they do have safety postings, and that's what she called them. They have safety postings, but they continue to have trespassers.
Well, safety postings might get you off the hook relative to adults, people 18 years and older, but there's a different standard for less than 18 years old. The other thing that I'd want to bring in at this point, because we had posted that this would also involve insurance, is that one of the biggest issues in this, of course, is, does insurance cover me? And in general, as a general rule, insurance is going to cover all of these situations. There are many exceptions to insurance policies and a lot of fine print and a lot of legal mumbo jumbo that we're going to try to get into as we move along. But in
Okay.
general, the key is that you need to have the appropriate insurance. As an association, there is D&O, director insurance. When as a director of your association, you should have insurance for your directors, and also be very clear with your insurance company, whether it's Allstate or State Farm or whomever, that in fact that the association, whether it owns property, if it owns a beach, that's a whole different level of insurance coverage beyond just insuring the directors.
Okay. And then as far as insurance coverage, is that something you want to talk about later, or?
What's the question? And I'll
It says it may be a requirement of the insurance coverage that a person needs to sue to actually access insurance benefit coverage. Are you gonna talk about that?
I can talk about it, but let's move along further.
Okay, sure.
Questions. Let me think about it while we're talking.
Yeah, no, that's fine. All right, we'll move on.
So,
and I have not forgotten your questions, everyone. We will make sure that we cover some of them, some of the other ones.
And I apologize to everybody, but I kind of wanted to get some of these other things out before we get to the other questions. So it's a big difference when a trespasser is a child. And remember, in Michigan, a child is someone who's even 1 day short of their 18th birthday. So if the trespasser to your land, your boat, or your dock is a child, you have a duty to exercise reasonable care to keep your land, boat, or dock reasonably safe for a child if any of the following are true. One, that the child is injured by an artificial condition. And this kind of goes back to when the comment about a natural condition or not. Child was injured by an artificial condition, or you knew or had reason to know a child would likely trespass, or you knew or should have known about the dangerous condition and realized or should have realized that it would involve an unreasonable risk of death or serious injury or harm to a child, or the child trespasser did not discover the condition or realize the risk involved in meddling with it, playing with it, whatever, or coming within the area made dangerous, or the usefulness to you of maintaining the condition and the burden of eliminating the danger or slight as compared to the risk of trespassing to the trespassing child, or 6, you failed to exercise reasonable care to eliminate the danger or otherwise to protect the child. So what are we talking about here, and how does this impact us? This means that if, for example, you have a water toy, a big float that's tied up to your dock, and you love to use it, and the kids love it, and the grandkids love it, and you leave it tied up when you're not there over the weekends. A child trespasser, as opposed to an adult, comes and uses this during the week when you're not there and gets severely injured or, God forbid, killed on this toy. Are you liable to this trespasser? What kind of duty do you have the trespasser? So because it's a child, if any of those 6 things were present, which I think they would be present, because if nothing else, you did not exercise reasonable care to eliminate the danger, which was you could have let the air out of the thing and pulled it up on land, that you're now liable, and your insurance company are liable, for this child, for this minor's injury or death. So when it comes to minors or children, you have that same high burden as opposed to typical trespassers. There's a very low burden of duty. Okay, now let's stop and see if there's more questions.
All right. Okay, so clarification on the invitee versus leasee piece, is a short-term renter, what would they be considered?
They would be considered a invitee that you would owe a high burden to them. If you rent like Airbnb or one of the other companies, you are doing that for you're making money on it, that they are a business for you. So you have a very high level of due care and caution. So if someone gets hurt on your property through an Airbnb person and you haven't had them sign waivers, which you can have Airbnb people, your guests sign waivers, then and that's something that I suggest and produce a waiver document. Particularly if you allow them to use any of your watercraft, if you allow them to use your kayaks or your sailboats or your canoes, you're liable to that Airbnb guest at the highest level of duty. So in
All
other
right.
words,
I'm
it's
sorry.
very easy. It's much easier for an Airbnb guest to hold you liable than it is for just a friend of yours, and who's much easier to hold you liable than a trespasser.
Okay. All right. And then related to that, let's say an association is selling cookies. So if they have people come and buying cookies from them, does that make, I guess what they're asking is, does that make that an invitee, that person coming in?
The person who comes onto your property to sell you cookies?
Well, the question really says, if at an association meeting we sell cookies, does that make us an invitee?
If you go to the association meeting to buy cookies, are you an invitee? So does the association owe you that higher level of care? There may be a question in the law that I need to dig into as to if there is a combination of social, you're invited because you're a social member, but you're there to buy cookies. There might be a combination between social and business that might relieve you of some of the highest duties, but I'd have to look to see if there's any case law. Again, these are more all the general principles that I wanted to get out. So again, there's a lot of exceptions in the law and there's a lot of case law, and just so everybody knows, there are statutes. So what I'm reading to you is my understanding of statutes, Michigan statutes, as to what your liability is. And then judges have considered the statutes over the law. So when a judge writes an opinion at the county level, and then it gets appealed to the Court of Appeals and appealed to the Michigan Supreme Court, and those courts publish, typically the Court of Appeals and the Supreme Court publish their opinions, those opinions become, those analyses of the law become part of the law, known as case law or common law. So without researching all of those, if there's one particular instance that deals with that, hard to answer.
Yep. And then we had some questions about insurance. And Sherry Kurdiak, I tried to unmute you. So if you had your hand raised, if you wanted to ask a question, you can do so. You need to unmute yourself, I believe. But other questions about insurance, let's see. What considerations should the officers or board of a lake association insurance include? So I think that was back to your directors and officers comment.
So the E&O, which is sometimes called an errors and omission policy, or D&O, which is called directors and omission, either one, it's the same type of insurance. It should include, and I say it that you really have to talk, someone needs to talk face-to-face. I guess face-to-face now means by Zoom meeting as opposed to actual face-to-face these days, but certainly by Zoom meeting with your salesperson to say, this is what we do as an association. If your association doesn't own land there's a lot of insurance you don't need. If the association owns an island or owns a playhouse or owns a beach, then there's a lot more insurance. If the association doesn't typically put on much in the way of events except holds meetings at the local restaurant, there may be less insurance than if in fact you hold an annual picnic at land that the association owns where people can get hurt on the land. So what it should include really depends. I would certainly advise that as far as an association, excuse me, my grandson Remy, I'm working, can you please, thank you. Thank you, Remy. So for a riparian rights association, it's important to let your salesperson know that you are a water related association, because anytime there's water and the chance of dying and boats, there's a whole different type of insurance that's available. And I say that also in terms that as cottage owners, we get homeowners insurance, which is totally separate usually from boat owners insurance. And the two are not the same. As a matter of fact, it sounds like people want to hear a little bit about insurance, but in the typical standard insurance policy in Michigan that you buy for your cottage or for your home, even if you tell your salesperson your insurance salesperson it's your cottage, that the regular homeowner's insurance will cover, I made some notes from some insurance policies, that the typical insurance policy will cover all boats if they're less than 16 feet and less than, I think it was 25 horsepower. So if you own a boat, motorized or not, 16 feet or longer, including a kayak, that you have to get a separate boat policy or boat rider. Different insurance companies call it different things, but it's actually a different set of documents where you are insured against you hurting somebody with your boat. It doesn't matter if it's what kind of boat it really is, but it's the length of the boat and the size of the horsepower of the motor. So that's real important.
And the question Sherry was trying to ask, she did get a chance to type it in. She says that she has a question about rafts. What are the liabilities of having a raft in front of your cottage?
There's giant liabilities having a raft. There was a case that I read about, and it was several years ago, where someone drove into a floating raft, and part of the theory of liability was the raft was too far out, and they drove into the boat at dusk, and they drove into the floating dock. So having a floating dock, as far as a boat hitting it, although the odds are very low, that can happen. And the other thing is that whether a child or an adult is in your shallow water or in your deep water off your dock, the same duty of care applies. Plus, I would say that a floating dock in the deep water, that you as the homeowner, as the dock owner, know that it is more dangerous than swimming in the shallow end. And that with knowing that, and again, what we just read about minors with somebody less than 18 years of age, I think there's great liability with a floating dock. And again, as long as you disclose it to your insurance salesperson, and by disclose, I mean in writing, not orally. I know wonderful insurance salespeople, and certainly insurance salespeople that I trust. But I would tell you, my advice is that if you were filling out a form for insurance, that you fill it out yourself. Oftentimes, people want to fill it out for you to make it easier for you, but you want to fill it out yourself to make sure you include everything relative to what you have. And a floating dock would be something that you want to put in writing to make sure that you have insurance on. And I say that in terms that every cottage insurance and homeowner insurance policy that I've seen has a clause in it where they don't have to pay if you have either misrepresented something to them on your application. So misrepresenting meaning that you intentionally maybe did something or maybe negligently, but also that if you simply don't put out all of the facts for them in figuring out how much they should charge you. And there's also a clause in every policy saying that you have to keep them updated as to what you have. So if you get a floating dock and you don't tell them, they may say, this is the insurance company, well, you didn't tell us that, so we don't have to insure. So putting everything in writing to your insurance company on an application or an updated application of renewal is extremely important, I believe, to do it yourself.
All right, and then there were a couple of questions about the liability waivers that you mentioned. The gentleman who was talking about the walking trails that he has his neighbors use, he's concerned that maybe he should have his neighbors sign liability waivers, and are there standard forms he can download? And then also a question about whether if you personally create or prepare liability waivers, like forms for people.
I do personally create liability waivers, and I have created them for other people as well as for me to use with people. I don't know if there are standard waivers because there's thousands of waivers on the internet, and there are standard waivers by the dozen. It also depends on state by state because the case law that we were just talking about is by state. It's not one judge across the whole country. This is not talking about U.S. Supreme Court. This is talking all about Michigan courts, your local county court, your local Court of Appeals, your local meaning Michigan Supreme Court. So I do, and you can call or email me.
So would you recommend the waivers for neighbors who are using nature trails?
I do. I'd want to talk to somebody first. It's very simple, one page, easy. Sometimes it depends on the relationship with the neighbor. That's what I recommend.
And then this is a good question. Is there a resource that keeps track of cottage liability cases in Michigan?
Not that I know. I wish there was. It'd make it really easy. No,
yeah, so there's nothing comprehensive. Okay. Yeah,
no,
they were.
No.
Okay.
I would. No, there really isn't. You have to research it, or you have to do the law a lot. I would tell you that Cliff Bloom, although Cliff isn't a liability lawyer, he's a cottage lawyer in terms of many issues with cottages, and he's a great resource. And the articles that he writes for Michigan Lake and Stream Association are a great resource. He's a tremendously competent lawyer in this area. But again, although what he and I do kind of overlap a little bit, and I love listening and talking to Cliff, we also do kind of separate things, or from the angle of negligence, as opposed to he does a lot of the land use stuff and the zoning stuff.
Mm-hmm. All right, I think at this point we can move on. I am going to acknowledge there are a couple of other questions, but they might be ones that either you're going to respond to naturally or we can check in with later.
Okay.
I think this was your last statement.
Yes. So I put this in about non-delegable duties because some people think, well, I'll just have someone take care of something. For example, you don't put in your own docks, you don't put in your own hoist, somebody puts in the boat. So you think, I'm off the hook. They take care of all that. The law in Michigan says as an owner or possessor. So owner meaning I own the land, I own the cottage. A possessor meaning maybe I rent it for a month at a time. Either land, boat, and or dock. Whatever level of legal duties, meaning those types of duties we've talked about, you may not delegate to others, and you are ultimately legally responsible for. So in other words, hey, I have someone put in my hoist in my dock, and if someone gets hurt on it, that's going to be their fault and their insurance. That might be true, that it might be their fault and their insurance, but ultimately the buck stops with you as the owner or possessor. It's your fault as a matter of law, whether or not you had anything to do with the dock actually going in. So if the dock, I'll give you an example. The hoist is put in typically inches from your dock, your boat hoist. It happens that your hoist people put it in this year and it's this far apart. Not such a big deal until someone steps from the dock to your hoist and their leg goes down and they break their leg. You didn't put the hoist too far from your dock. Your hoist people did, your dock people did. It doesn't matter. You and them are both responsible, and you and them, as far as insurance, are also both legally responsible. So it doesn't relieve you of liability. If you own your cottage, you're it, and your insurance is it, no matter what anyone else has done or not done. Okay, so we can now move on. We have some pictures. So this is a picture from my cottage looking out in the morning on our lake, Portage Lake. We have, my docks are straight in front of us, neighbor's dock is to the right. And I just show this because, number one, if you see on my dock, I have a hoist. I also have a rowboat. I also have a, I don't know what that was at the time, because now I also have a little sailboat. But I'm liable for all of those things, and those are just different things that people can get hurt on. The other thing that I would point out to you is that on the bottom of the picture, you can see that maybe you can't, but I just have stones. Next to me, they have a wall. If someone, which is often a child, gets too close to the stones and falls down the stones and gets hurt, again, I said a child, just so you know, I and my insurance are going to be responsible. So I know there's stones there. I warn parents, and the answer is if some little kid gets too close and falls and gets hurt, I'm still on the hook. So that's morning on Portage Lake, one of the many Portage Lakes in Michigan. So here's an activity that I look at and say, oh, well, here's liability. So this person's skiing. There are almost no other boats out. There are a variety of rules, regulations, statutes, ordinances that apply to skiing. For example, you are, let me see if I can find it, that you cannot, or you are supposedly not allowed to ski. There are ski requirements, and I believe it's something like you're not supposed to ski before 8 in the morning. I might be wrong on that. It might be 7, according to state law, and you can't ski from dusk on. So relating this to what we talked about before, if I ski this person and let's say that it's dusk, it's almost dark, but the lake is nice and clear, and there's no other boats, so I think it's a great time to ski, and this person gets hurt, I have violated a statute or regulation, so there's going to be legal inference that I am the wrongdoer here, whether or not I had anything to do with the person getting hurt other than I was pulling the boat and maybe they were a bad skier. So skiing,
the regulation, just so you know, Mark, is an hour before sunrise to an hour after sunset is the way that goes for skiing.
What are you reading from?
That's the Michigan boating law.
Is that Rule 281.747.22?
I don't know what number it is.
Anyway, so there are a variety of regulations that are very, very fine. And I would also tell you that many, but thank you, Melissa, that many Municipalities, villages, and townships have skiing rules, I have found, depending on the holiday, depending on the day and the day of the week and the time of day. And all of those apply as ordinance rules. Okay, next slide. Dogs. So this is Lucille. Lucille's very sweet. The question is, if Lucille bites somebody, social guest, invitee, licensee, am I on the hook? The answer is that you are on the hook for your dog biting someone no matter what. A long, long time ago, there was one free bite theory. In other words, hey, my dog's never bit someone, so until my dog bites someone, how can I be liable? The answer is you're automatically liable, except in extreme situations. For example, if someone comes up and kicks your dog really hard in the middle of nowhere for no reason. But other than that, if your dog bites somebody, you're going to pay, or your insurance is going to pay. Dogs are one of the things that you have to tell your, I should say you don't have to, but you better tell your salesperson, your insurance company about. I've listed here standard homeowners insurance, and many of us have better than standard insurance, but standard homeowners insurance in Michigan, I've seen the following dogs excluded from coverage. In other words, if you have this dog and it bites someone, you're liable and your insurance company isn't. Pit bull breeds, Rottweiler breeds, Chow Chows, Akita, Doberman Pinscher, Mastiff, Wolf hybrids, and German Shepherds. I was surprised that German Shepherds is on the list. Oftentimes with better insurance and higher limits, these exclusions are left out and you are covered. But check with your insurance company. So Lucille better not bite anybody. Next question. So you have friends come and kayak. Our friends come, they have little kids. Oh, we know how to kayak, we know how to swim, we're fine. You owe them, because they're minors and their parents are with them, despite their parents being with them, you owe them that high level of care because these kids are under the age of 18. So if something happens, whether or not they're at the cottage, whether or not they're on the other side of the lake, those are my kayaks. So I'm on the hook and my insurance company's on the hook. So when you have your friends out, talk to them first about how good a swimmer they are and if they've really kayaked before. Next slide. Tubing. We love tubing. The kids love tubing. They always say, try to throw me off. We've never had anybody hurt on tubing. We've had someone hurt skiing, but never tubing. Tubing is one of those activities that typically, I would say 99.9% of the time, it's with someone who's a minor, who's under the age of 18. So you and I, as the boat owner, owe that cute little kid a very high level of duty of care. Next slide. So this is a full moon at night. We try to go kayaking at full moons. It's wonderful. It's lovely. It's quiet. There's usually no other boats around. Maybe there's good reason there aren't boats around, but I think this was actually a super moon, and it's really nice. But is it risky? It's kind of for being out on a kayak. Maybe it's a high risk activity. It's not something I've disclosed to my insurance carrier. I think I have to. But kind of my point is that we do things, and we've done that for years, where if I look back on it, it's kind of like that's pretty risky, because if I had someone out and they overturned and it was difficult to see them, could have been a bad situation. However, I think that insurance would still cover it. Again, we learned that insurance covers whether you're negligent or grossly negligent, and even if they said, Teicher, you're grossly negligent, you took your friend out at night, insurance would still cover. Next slide. So these are eggs from one of our local farmer. Lovely eggs, green, brown, white, which I learned is because of the breed of chicken, not what they feed them. And I include this because the eggs are wonderful, the eggs are great, the eggs are organic. However, keep in mind that what food you serve people, you are liable for. Whether it's food poisoning, whether it's something else, you are on the hook. So, fireworks. We love fireworks. Our lake has giant fireworks every year. We used to do fireworks like this, where that's just a sparkler. However, Michigan law says that if you do an activity defined as ultra hazardous, such as allowing someone to hold a piece of metal that is hundreds and hundreds of degrees hot in their hand and they get burned, you are automatically liable. It doesn't matter if they were at fault. It doesn't matter if they were drunk. You are liable. This is the type of activity where you are responsible for it no matter what, if they're on your dock or your boat or your property. Next. Most of our pictures, and we think of cottages, at least most of us, in the summer. However, in the winter, people can use the cottage. The rest of the lake, as you can see, is all frozen. This is an area between two lakes where some waters, where the water is moving. So in the rest of the lake, you could probably walk on it and you wouldn't even hear a crack. But when you get closer, or you have a guest that gets closer to this moving water from lake to lake, they could fall in. And again, you're liable, you're responsible. It's not your property. It's not on your property. It's not on your boat or dock. But if they're your guest and there's a reasonable expectation that they're walking out there, you should have expected it or should have anticipated it. You're going to be liable on the hook. And so is your insurance. Next. So I put this in. A friend of mine has a tractor, and I said, oh, can I get on it and drive it? And it was fun and it was great. But I put this in for a couple reasons, but particularly that under Michigan law, if you let someone drive your tractor or your car or your boat, the person who's driving it, and let's say hurts someone, that operator is liable for injuries that person causes. However, you as the owner, in this case, my friend who owns the tractor, or me, if I invite you over and let you drive my boat and you injure someone, I'm also responsible for those injuries. So Michigan law says both the owner and operator are liable. So the owner and operator are going to get sued. Why do I say it like that? Because if you and your husband or wife, your spouse, you are both listed as the owner of your boat or your car or your tractor, and you loan your boat or tractor or car out, and that person injures someone and there's a lawsuit, that lawsuit's going to name your friend that was the driver and is going to name you and name your spouse also. Why is that important? Because if in fact a judgment is had, and the judgment includes you and your spouse, and you own real estate together, they may be able to get to your real estate. Why do I say that? If in fact you or me, I own the boat, my wife doesn't, her name's not on the title, I let a friend drive, the friend hurt somebody, or in fact I hurt somebody through negligence, and there's a lawsuit, they can't sue my wife, they can only sue me. So if there's a judgment in excess of my insurance, they can only get to my assets, generally not assets owned by both me and my wife together. So one big recommendation and takeaway, I hope, is that you look at your tractor title, your car title, and your boat title, and think about, wait, who's the owner of this and who would get sued? Next. So this is me with a fish. Actually, this was a fish that a neighbor caught. I didn't catch this, but it was a nice looking fish. We took a picture. I did this because we've had people out and people get stabbed with fishing hooks and caught, not badly, but certainly You can't get hurt bad with a fishing hook. If someone you invite out gets injured with a fishing hook, again, you're, no pun intended, you're on the hook. Next. This is how we get fresh corn in the summer. We go out to the farmer and hop on their truck. Why is this here? Because if I have a friend out and he comes out and we go out somewhere and I take him to say, let's go pick some fresh corn, and he gets hurt, who's liable? He is a guest of mine. I could be liable even though we're not on my property. The farm might be liable, and the farmer's, in this case, auto insurance might be liable. But if you take someone, as I did here, specifically out to the cottage and out to pick corn off the truck, you're still on the hook. Next. So you're kayaking. As we kayak and you come upon the flowers, and they're beautiful, and you're not allowed to pick these flowers, but someone leans out on the kayak and they fall over the kayak to look at the flowers, I would just make sure you know that you're liable, and I hope they're wearing their life jacket. Life jackets are required. Not only is there state law, but there are rules and regulations as to what kayak is, what life jacket is necessary for what kind of boating, for personal watercraft, or whatever. Next. This is another moonlight kayaking, and I already talked about that, so let's go on. Oh, that's me. I had a couple other thoughts that I wanted to share. So relative to insurance, oh, we can go back to go back one. It's a lot prettier to look at than that. Although that's important too, but anyway, so we can look at the evening kayaking. That relative to insurance, I noted in some insurance policies, I'm looking at some notes that I reviewed in preparation for this, that if you do not disclose that part of your cottage is being used, for example, for Airbnb, so it's using even at all for business purposes, that your insurance company can not only cancel you for that, but can deny any coverage whatsoever, whether it's related to some Airbnb renter getting hurt or anybody else. So I'd say be careful. Another important thing to look at is in your insurance contract. And a couple that I looked at all said that if you want to sue your insurance carrier because they didn't do something right for you, they didn't supply coverage. In Michigan, the typical statute of limitation, which means the time you have to sue, is 6 years for a breach of contract. In all of the insurance policies that I reviewed from various companies, they all included a 1 year by getting the policy, you're agreeing to a 1 year statute of limitation to sue your own insurance carrier. Something that I think you should know about. Relative to docks, the insurance people that I talked to before and in preparation for this said that docks are typically, as a matter of standard practice, included under your homeowner's insurance. That we riparians all have at least docks, that they're included. The big thing that's not included is any boat with a motor either beyond 16 feet or longer, or with a horsepower motor over 25 horsepower. That's when there is a separate insurance policy or a separate rider, some companies call it. Okay, with that, I'll stop and see if there are any other questions.
Sure. We have a question from Leslie. She asks if, quote, attractive nuisance comes into this.
Yes, it does. I don't have any notes about attractive nuisance in front of me. But yes, and that typically regards minors, that if a minor is attracted to something where they might get hurt, we talked about your very high level of duty of care to minors. Anytime there's kids around, not that you should get nervous, but call your insurance agent and raise the amount of insurance you have.
Okay. Another question. If an association allows mooring by backlot owners as are they taking on a large amount of liability on behalf of the association members?
I guess I'd have to ask, is that allowing the mooring of boats on whose property? On association property, on some individual's property? If the
Yeah,
question,
there's a secondary question. It said, could a guest of a backlot owner injured at a mooring site, which is on an association property, sue not only the association, but also the members of the association as individuals? So it sounds like it is association property.
so the answer is yes as to the association. I would hope that your association has incorporated, is a company or an Inc. or an LLC or something like that. And the reason is that if it is a separate legal entity, then it is, for all intents and purposes, legally a separate legal person. So that person, that entity owns the property. I as a member, you as a member, we don't own it, but our legal entity owns it. And our legal entity, we'd make sure that it has the appropriate insurance. But the answer is yes, that backlot owner could sue. Yes.
Okay, and then related to that, do you recommend titling a cottage a certain way, like an LLC, for example? Does that make any difference?
Well, that's a tough question because it in part depends on family dynamics. Um, there are sometimes big family issues when a grandparent owns the property and has either deeded it to all the children or deeded it to one child and forgot to put on everybody else, or deeded it to nobody, as to how do we set it up, whether it's a corporation or not. That's a real case-by-case situation. So my answer is that's a very answer case by case.
Okay. How about if I leave the...
There's pros and cons both ways on making an LLC.
Mm-hmm. Okay, and if I leave the keys in my boat, kids unknown to me get in my boat and take a joyride and get injured, is that a problem for me?
Well, if we go back to applying the rules from the beginning, the answer is that I don't think I would want a jury decide my liability if a jury heard that I leave the keys in the boat and some minors. And again, it doesn't matter if the child is 17 and a half or 7. It's your same high level of duty. And that if you leave those, I think you're going to be on the hook as a general rule.
Mm-hmm. Okay, if a group of non-lakefront people install a dock on a township road end without permission from the township and someone gets hurt, who is liable? The people, the township, or both?
Well, the people would definitely be liable. The township might, depending on what they knew or should have known. For example, if in fact there had been complaints and the township said, don't worry, be happy, we don't care, it'll be fine. That's one thing. If it goes up and the next day someone gets hurt and the township has not even been notified about it, I don't think the township would be on the hook.
Okay. You mentioned that if there are people, especially children, in the water on the bottomlands, we're liable for possible injuries. So one, I know that boaters can anchor and swim, but are they legally allowed on my bottomlands? And then two, what can an owner do when people refuse to leave property above the water and or the bottomlands? So I think this is getting to like people who come, from the lake and anchor.
Yeah,
My
this is
understanding.
a major issue, and I know that Cliff Bloom has written about it, and I've heard him speak about it. And it's kind of a moving target because the Michigan Court of Appeals and Supreme Court, I think, have dealt with it relatively recently. Uh, if you own the bottomland, and as a riparian, we all know how important it is the land under the water where we put our docks and boats, if we own it or not. And if we own it, then people, the law in general says people can maybe throw an anchor down temporarily and certainly can't stay overnight or things like that, uh, as long as they're doing temporary things. So I think that, and I without researching it, I don't know for sure, but my guess would be if in fact your land goes out pretty far where people can still walk on your land, it would be very difficult to get them to be removed, because when you call the police or the sheriff deputy, whatever, the water patrol, what you will hear a lot is, oh, it sounds like a civil matter and we're not going to do anything. So I always advise people call the sheriff or the township police anyway. If nothing else, you maybe can get them to say to them, you know, you really should move. If nothing else, make somebody happy, but because you could be liable if someone's on your bottom land, and not just that someone's swimming and gets hurt, but if in fact there is something dangerous down there, if there is an old uh, metal post that's from a dock that's down there that's impossible to get out, but someone jumps off a boat and gets cut on it, and it's in your land, you own that bottom land the same as if it's the dry land 10 feet from the shore on near your house. Um, so yes, it's a tough issue.
Okay, there was a situation where someone was knocked over by two very large dogs while walking her dog on a leash past a private home on a private road. She was a property owner of a shared access private road, so it wasn't someone else's private road. She broke her hip, but the insurance said that they would not cover her injuries unless she sued the property owner where the attacking dogs originated from. So I think this goes back to that question about, do you need to sue in order to receive an insurance benefit, I think.
Most insurance companies that I've dealt with as an adversary don't want a lawsuit because they want to resolve things. But perhaps in this situation, if they feel that there is another proximate cause, that there is someone else at fault, and they want that person brought into it to help settle the case. For example, the fractured hip, let's pick a number, is worth $100,000, and one insurance company says, okay, well, we're half at fault, we'll pay 50, we want the other people to pay 50, and the other people say, we're not going to even tell you who our insurance company is, and you have to sue them. That would bring them in to be able to get a settlement of $100,000 and everyone resolve the matter. So that might be what's going on, but most insurance companies want to resolve it without a lawsuit.
Okay. All right. A question about what you were mentioning about titles. So the question is, what you're saying is that, okay, I'll just read what it says because I'm trying to paraphrase, but so you're saying if your name is the only name on the title, they cannot go after assets in both your wife's name and yours. Basically, they can only go after assets in just your name.
That's the general rule.
Okay.
That's not a slam dunk, but that's the general rule. And specifically, like your house, they can't go after your house if you own it with your husband or wife or spouse. As
Okay.
opposed
And
to if you have a bank account in your name alone and you get sued and there's a judgment against you, they can get it. That's the general rule.
okay. So, and then connected to that, is there a reason why people might hold their, is this the reason why people might hold their private real estate property in a trust?
It is one reason.
Okay.
But there's pros and cons in holding it in a trust because then the trust can get sued. Again, the trust is kind of a legal person, just like you and me, or just like Teicher de Simone LLC. That LLC becomes a legal person And if that trust holds all of our assets, then that trust can be sued in all of those assets. So there's pros and cons to all of this, and it's very case by case, person by person, how much risk someone wants to take, how people feel about things.
Mm-hmm. Okay, we have a couple of boat questions. One is, you were talking about types of boats that are covered under your, your property insurance versus ones you need extra insurance for. So like a non-motorized 18-foot canoe, would that be covered by standard insurance, or would you need extra insurance on a non-motorized?
The standard insurance that I found talked about 16 feet, but I know, so that would be kind of like the most basic insurance, the most, kind of the cheapest. I've seen other insurance where it says automatically they'll cover up to 18 feet and a 45 horsepower. So there's kind of like different levels of insurance and insurance companies. So it really depends. But I always tell people, take a look at your insurance. And although most of us can't make heads or tail out of most of it, you can usually find where there's a clause that talks about, and you see 45 horsepower or 25 horsepower, and it's real easy to spot because it stands out.
Okay.
Oftentimes, a good thing to do is go to your insurance policy. There's a table of contents, and look for where it says watercraft. And usually there's a separate section just for watercraft.
All right, it looks like we just have a couple of questions left. One question is about wake boats. If they cause damage on docks or docked boats, is there liability for that?
That's something that I think is going to be making its way through the courts right now. Wake boats, I know people love them. The evidence that I've seen and heard is that they can be very destructive, creating waves, both horizontal waves, so the waves come and hurt a boat or a shore, or flip over a kayaker, as well as going down and hurting the bottom of a lake, causing environmental damage. So I think it's something that we're going to be finding out about soon as cases make their way through the courts.
Okay, here's a question about a board of directors. Are the board of directors financially liable for a lawsuit against the association if there are insufficient assets held by the association?
They may be, but in most instances, the answer is no, that there's insurance. I guess I'd have to, if the questioner could give me something more specific.
I'll see if they get back to us. There's an.
I mean, I would phrase it this way: that if in fact someone gets hurt on association property and there's a lawsuit, and the organization is a corporation, is a legal entity, and gets sued, and there's $2 million of insurance, which would be, I think, pretty standard, and the judgment's for $3 million because, God forbid, someone gets killed, let's say, or they're a quadriplegic, and there's a $3 million judgment, the insurance company turns over $2 million, that other million, the collection would most probably just against the corporation and whatever asset it owns, if any. And usually it does not go to against the individual directors or officers.
Okay. All right, so there's also a question about liability related to the water from your well. What kind of liability do you have there?
It's really the same as the picture of the eggs, that you're responsible, which is a little scary in this day and age of PFAS and all the chemicals that we're just finding out about. So the answer is, if you can afford to get your water tested, if you have a well, for example, do it. It's a scary world out there, not only with the virus, but with all these chemicals that all of us have historically cooperated in allowing to be put into the environment.
And then what are some examples of inference with your neighbor's rights?
Inference or interference?
Oh, I'm sorry. It's interference. I pronounced it incorrectly. My fault.
No, no problem. Well, interference, I guess it depends what rights. Yeah, there's lots of kinds of interference. If in fact uh, you put your fence on their side of the lot line, and you take property, that's certainly one kind of interference. Another kind of interference is for us riparians is if the properties come at an angle and you put up your hoist so it blocks part of where your neighbor can go out and use their land, that might be major interference if that's where they usually put their dock, but you got your hoist put up first. That might be a big problem, and it might depend on who owns the underwater rights, which is a whole nother thing that that I'd probably say call Cliff Bloom about.
Yeah, and he talked about that last week a little bit.
Okay.
And then I think also related to that, there's a question about your septic system. Like if your septic system leaks into the groundwater, contaminating someone else's well or surface water, is there a liability associated with that?
There may be. I think that's a specific liability that I have to research, but yes, they're very well, maybe depending on what you knew or should have known. Again, if we go back to the duties, what kind of duty you have, if there's a duty to keep your well operating, that's one thing. If you don't know that it's leaking, that might be another. But if you know it's leaking and you say, ah, what the heck, it's not leaking much, but it happens to make your neighbor's well polluted, I think you could certainly be liable for their damages.
And someone was asking, are you dealing with some PFAS cases yourself?
I am not dealing with any PFAS cases yet. I personally at our cottage put in the best anti-PFAS and anti-chemical system that I could last year, because now I have a grandchild. I'm already polluted. I'm hoping to keep my grandchild as non-polluted as possible. I think it is a major issue and a major terrible chemical from everything and all the research I've read. It is some of the worst of the worst. And it doesn't go away.
Yeah. And then Anne says this is slightly off topic, but I don't know. I think it isn't. She wants to know if you've been thinking about the social events that are in the time of COVID. So for example, access to facilities, tennis courts, clubhouses, docks. She says that they have shared restrictions based on government's orders, but are you thinking about these issues at Portage Lake at all?
Not yet. I think we will be. However, I would, in just thinking out loud, that if in fact the governor order is still in play, for example, to wear masks, and you go to a common area and don't wear a mask, you have now violated what might be considered a state statute. Therefore, you're going to be liable for whatever damage or injury that causes. And if in fact someone says you made me sick, I think that you have now violated a statute, and there might be a legal inference that you have liability. So as long as there's the executive, whether you agree with it or not, as long as there's the executive order, as an attorney, I'd say follow it.
All right. Well, that's it for questions, Mark. That was very informative. I was on the edge of my seat the whole time.
The edge of your seat? Okay, so I just wanted to, Melissa, thank you for being the director producer. And I wanted to tell you, I did bring you a gift, Melissa. So
how did you know? I needed that.
Or I better mail it just in case I don't want you to run out. So this is my gift to you. Thank you so much, my thank you present. And otherwise, I just wanted to thank everybody for listening in and for being a member of MLSA.
Yes, thank you so much for joining us, everyone. We have more sessions coming up next week, next Friday. We are going to talk about harmful algal blooms, blue-green algae, and I know there's some liability that's possibly associated with that as well. So that will be a great topic. And then our last session on May 22nd is actually going to be at 2 p.m. and that one is about short-term rentals. So all of these topics definitely come together with liability, and we appreciate everyone coming. This session, as I said before, is recorded, so it will be available. Please feel free to check that out, share it with your friends. We did at the most, Mark, if you're interested, because I had some participants interested too, had 85 people today.
85.
So yeah, so people are interested. So thank you very much.
Thank you, number 85. I think that means I beat Cliff Bloom. I'm not sure.
Thank you very much, everybody, for joining us. And like I said, we hope to see you again soon. Join MLSA, subscribe to the Riparian, find us on Facebook. We'd be happy to interact with you. So
Yeah, before you go, I just wanted to make sure everybody knew that if you have any questions about MLSA, Melissa's wonderful. You can send her an email. You can call her. It's all on the website. And she's extremely responsible. I should say responsive. And we'll answer your questions.
all right. Thank you, Mark. Thank you very much. Everybody have a wonderful weekend.
Stay safe.
You too.